Oh, doctor, I started.
All right. It's 9 o'clock anyway. I think we should start.
Yeah, Dr. Riddhi, you can start, please.
Yes, ma'am. Am I audible?
Yeah.
You are.
Good evening to one and all. Today we are going to start with the 24th session of the Medico-Legal Committee from YOSI. The topic is medico-legal aspects related to outraging the modesty of women. These are the topics we have covered so far, ranging right from Consumer Protection Act to cataract, ROP, insurance laws, criminal laws, and the latest one being the last session was insurance laws in ophthalmology. Today's session deals with medical legal aspects related to outraging the modesty of women. Our panelists with us today, esteemed Dr. Anand Deshpande, sir. He is a director and eye surgeon at Guru Prasad Netra Rugnalaya at Aurangabad, chairman of the Indian Medical Legal Consulting Services Private Limited, chairman of the Medical Legal Committee of AIOS. He is faculty of law and visiting professor to Symbiosis Law College, Pune, National Law University, Aurangabad, and faculty of management services and sciences at BAMU, Aurangabad. He has written various books like Legal Aspects in Ophthalmology, to name a few. Our next panelist with us today is Dr. Prakash Marathi. He has been the past president of Maharashtra Ophthalmological Society, Pune Ophthalmological Society, and Indian Medical Association, Pune. He is a trustee of the Pune Ophthalmological Society and the IMA Pune. He is a member of the Medical Legal Committee of AIOS. He is the chairman of the Maharashtra chapter of International Society of Manual Small Incision Cataract Surgery. He is the past managing committee member of AIOS, past senior vice president of IMA Maharashtra State. He has also received the President's Appreciation Award by National IMA Headquarters in 2018 and in 2022. He has received the President's Appreciation Award in 2013, 2014, 2018, 2020, and 21. He has also received the President's Special Felicitation Award by IMA Maharashtra in 2021. He has also received the late Dr. Asha Kelkar Award in 2022 by Pune Ophthalmological Society.
Thank you.
Our next panelist with us is Dr. Manoj Chandra Mathur, sir. He is a senior consultant in glaucoma and comprehensive ophthalmology at Swaroop Eye Center, Hyderabad. Presently the honorary treasurer of AIOS. He is the past advisor and president of Telangana Ophthalmological Society and Hyderabad Ophthalmologists Association. He is the co-chairperson of Health Insurance and TPA Committee of AIOS. He has been a member of Medical Legal and Ethics Committee of AIOS in the past. He has been twice member of Managing Committee of AIOS. He has also served as a member of the advisory board of the Indian Journal of Ophthalmology. Our speaker for today is Dr. Chaitra Jayadev. She is the head of Vitreoretina services at Narayana Netralaya, Bangalore. She has trained from Bangalore Medical College and Research Institute. She has served the Indian Journal of Ophthalmology and AIOS in various capacities. She is currently the treasurer of the Vitreoretinal Surgeons Society of India and secretary of the Karnataka Ophthalmic Society. She has close to 180 PubMed indexed articles on subjects even beyond her core interest. She has completed her PhD in pediatric retinal imaging at the Maastricht University in Netherlands. She did a program on healthcare leadership at Harvard Medical School and is a fellow of the International Council of Ophthalmology at UCLA. She recently completed her postgraduate diploma in medical law and ethics from National Law School, Bangalore. She is the recipient of the prestigious Colonel Rangachari Award, the Rema Mohan Award, J.M. Pahwa Award, the IJO Honor, and the IJO Silver Awards. Can we, ma'am, begin with your presentation?
Yeah.
Welcome, ma'am.
Yeah, thank you. Nice to see Dr. Mathur. Hello, sir. Sir, you're muted.
Hello, Chaitra. How are you?
I'm good, sir.
Logged in from Dehradun.
Oh, nice.
I think your voice is breaking, ma'am.
Okay. Is my slide visible?
Yes, ma'am.
Okay, great. So thanks, YOSI, for giving me this opportunity. Yes, I did complete a degree in medical law and ethics from National Law School. But, most of our things that we learned there were very, very pertinent to medicine itself. It was a very intense course for those of you all who'd like to know a little bit more of it. It's a year long, a lot of studying. lot of theory papers to write, and of late, we've lost that touch to write theory, but the learnings were very interesting, very pertinent, and one thing that we realized, all of us who completed this degree, is that the law is actually very progressive in our country. When you compare it to the West, or when we compare it specifically to UK, from where we've picked up a lot of our laws from the British, our laws are very progressive. And one such is the prevention of sexual harassment at the workplace. The primary aim of this is creating a safe and respectful environment for working women in particular, but in general to everyone. So thanks, Yosi, again for giving me the opportunity to speak about it. Though, of course, I didn't learn it during my course of 1 year. A lot of reading I did do for this particular talk, and I'm hoping I'll be able to share some of the insights in this particular session. I have no financial disclosures, but I do have certain disclaimers. My talk is not a legal advice. Any names of doctors and institutes that are mentioned in the presentation are available on the public domain. No attempt is being made to show any colleague or any profession poor light. And these are the two sources from where I have got a lot of my material that I'll be presenting. Now, this is some interesting, statistics. Most important of them is that the days are gone when men used to be the sole breadwinners. If you see now, 1 out of every 4 employees in the workforce is a woman. And you do know that globalization has brought a radical change in the status of women worldwide. However, the sad thing is that 2 out of 5 women have experienced sexual harassment at work. What has happened is that there's a large influx of women in the mainstream workplace of India, and therefore this sexual harassment at workplace is assuming greater dimensions. And unfortunately, most of the organizations don't have a proper structure to address this harassment. Going forward, I just want to show you a simple poll that was taken by one of the agencies, and they asked women how common is, sexual harassment at workplace. More than 50% of them said they had experienced sexual harassment at their workplace. 25% of them were touched without invitation, and 20% of them experienced sexual advances. Now, the next question that was asked is, why don't you all report it? Why don't women report these incidents? Well, only 20% of them reported. Why the rest of them don't is because they think that the outcome is going to be poor or not equivalent to the amount of stress that they've undergone. And 16% of them also said that the situation worsened after they got reported, because the boss, is taking negative action against them, or the perpetrator is harassing them even more because probably the punishment that was given was not adequate enough, which is why we read about reports like this, where even in our own field, which you expect to be a safe field for our patients, for our colleagues, it's not. You see this is very just last month, where a Nair hospital doctor was found guilty of sexual harassment, and he was asked to be shifted out of that center till the student finishes her course. And that when you see that, you often wonder, we are doctors, aren't we supposed to be the, the protectors, the guardians, and the caregivers? When we can go to this, you will not be surprised at what else can happen in other work sectors. And at the other end, you have this, RG car horror, literally, and I don't think anything has come out of it now. It's close to, I think, 80 days now. Nothing has happened. And which is when, more awareness came about the POSH law and how it should be strictly enforced, not only in non-medical, but also very much more in medical institutes, medical colleges, where they have to form the IC or the ICC, and I will talk about that a little ahead. So we know that what workplace sexual harassment is. It's a form of gender discrimination which violates the fundamental right to equality and the right to life for a woman. These are under our constitution's articles 14, 15, and 21. What does it cause? an insecure and a hostile working environment for the woman who's getting harassed. It impedes the ability to deliver, and in this competitive world, I think it's very, very important. It affects their social and economic growth. What happens when a harassed woman leaves her job? She doesn't find another one. It's obviously hindering her growth, and it puts them through a lot of physical and emotional suffering. Now, let me go back to when the Indian system actually took cognizance of the fact that, we do have sexual harassment and it is not being recognized. This was in the landmark judgment of Vishaka versus State of Rajasthan. That is when, for the first time, the Supreme Court of India realized that we are not giving enough importance to sexual harassment. So this happened in 1992. This is an important, judgment that came after this incident where Banwari Devi, a Dalit woman, who was actually employed in the rural development program by the government itself. She was brutally gang raped on account of her efforts to stop child marriage. And that child marriage was happening in an upper caste, whereas she belonged to a Dalit, which is why they felt that she needs to be reprimanded and she was brutally raped. So, championing the cause, the women rights activists formed a banner of Vishaka, and they filed a PIL in the Supreme Court. This is when they acknowledged the glaring legislative inadequacy and acknowledged workplace sexual harassment as a human rights violation. And it took 16 years after Vishaka judgment for the POSH Act to be come into play. So, what does sexual harassment denote or imply? These are important because the same five come also in the POSH. Physical contact and advances, a demand or request for sexual favors, sexually colored remarks, showing pornography, any other unwelcome physical, verbal, or non-verbal conduct of sexual nature. All these come under sexual harassment. So, the same thing has been taken under POSH as well. So what happened post Vishaka? Yes, there were a lot of judgments. I'm not going to go into each one of them. But one of the important thing was a superior officer at a Delhi-based apparel export promotion council was found guilty of sexually harassing a subordinate female employee at workplace. What was important in this judgment was that it said that physical contact was not essential for harassment. It said that it can be any unwelcome advance, any request like came in Vishaka, or any verbal or physical contact. So this was one important judgment which said that no physical contact is not required. Now coming to POSH, and like I said, it took a really long time for it to come in, but it was finally enacted in 2013 and the rules were also given. The year 2013 also witnessed the Criminal Law Amendment Act, which again criminalized offenses such as sexual harassment, stalking, and voyeurism. So coincidentally, both these happened in the same year. The POSH Act, what is the main objective is to prevent and protect women against sexual harassment and ensure redressal. That is very, very important. And they've really put it into place as to how these complaints can be addressed. Now, this is just a brief overview of how long it takes for a bill to be enacted. It started in 2007 and finally December 9th, 2013 was the Indian Ministry of Women and Child Development notified it as the effective date for the POSH Act and the POSH rules. Now, let's quickly look at some of the key provisions of the POSH Act. What is the applicability and the scope? Yes, it extends to the whole of India. The definition of an aggrieved woman is very, very important. It can be any age, employed or not, and who says that she was subjected to an act of sexual harassment. So this does not necessitate that the woman has to be an employee. Even a customer or a client, a patient, a day wager, anybody can be an aggrieved woman. But one thing that comes under the POSH Act is that this incident of the sexual harassment should have taken at the workplace. But what they have done is the workplace definition has widened over the last couple of years in a couple of judgments that I'll speak about. And another important thing, unfortunately, for the men who are listening is that POSH Act is not gender neutral, which means it's not applicable to men. So you can't go and file under POSH. Of course, you have other legal routes, but not POSH for men. Now, like I said, a aggrieved woman could be a working woman. She could be visiting a workplace, could be a student. And by working, it could be a domestic worker, a temporary, ad hoc. It could be for voluntary. Even somebody working in a camp for voluntary can still be an aggrieved woman. Anything. So any of them can come under that. Now, what are the bodies that are covered under POSH? It can be any of the sectors, organized, unorganized, institutes, a house, a dwelling place, because that's where your maid is coming to work, private, public, non-governmental, NGOs, anything. And now, coming to what under POSH amounts to sexual harassment, besides those 5 things that I already mentioned, they've also included something called as circumstances. And what are these? Where you give preferential treatment in exchange for sexual favors, or detrimental treatment when you don't comply, when you are threatened with present or future employment status, intimidating or offensive or a hostile work environment, and humiliating treatment. Any of these will also come under sexual harassment in POSH. Now, this is a very interesting thing. This was before POSH came in. This happened in 2010 in the High Court of Delhi, where it said that sexual harassment is a very subjective experience. What they mean to say is that the perspective of men and women are very, very different. For example, for a man, something that is a harmless social interaction for a sensitive woman might amount to sexual harassment, which is why POSH was made strong to include all these subtleties also, so that things can become more clear or lucid. So this is again an interesting case, but the person who complained actually did not comply with the inquiry, I think, committee, which is why she lost the case. Now, coming to the committee, like I said, the redressal system has been made very, very strong. And this is the complaints committees. There are quite a few of them. It used to be called the Internal Complaints Committee, but it's now just called the Internal Committee now. So you can either call it ICC or IC. So POSH Act requires an employer to set up an ICC at each and every branch of the office. It can't be just the head office. And any branch that has employed more than 10, yes, you need to constitute an ICC. And this is basically for the redressal processes, and failure to comply. An organization, when it fails to comply, will have to pay a fine. Now, this is the basically, what is the IC comprised of? It should be headed by somebody called as a presiding officer, who will be a senior female employee. 2 other employees also need to be employed as the IC. An external member also should be included, preferably somebody who's worked, in an NGO or something related to women upliftment. Like I said, she should be committed to the cause of women's safety. And 50% of the IC members should be women. That is mandatory. And the members can hold their position for only up to 3 years. And then a new person will need to be put in. And the IC should be constituted in every administrative division of the organization. So this is generally how it is structured. What are the reasons to disqualify an IC member? Any confidentiality breach, abuse of power, found guilty, convicted, any of this, you will disqualify the IC member. So some practical tips for the HR or for IC constitution is, as much as possible, the members should be trained on the POSH Act. They should know their roles and responsibilities. Have an odd number of members to arrive at a decision, when there's a divided opinion. They should be accessible, approachable, committed, sensitive, and understanding, preferably. They should be made autonomous, no scope of any bias or favoritism then. And give a separate office, if possible, to store their records and to have their meetings. And there should be periodic discussions, because, these rules can sometimes be amended and they should be updated. Now, for a company that has less than 10 employees, or it's an unorganized sector, or when the complaint is against the employer himself, then there are also something called as local committees at the district level. Now, this is also becomes relevant when it's a domestic worker. They don't know where to go. So these committees are also quite important. Now, important to note that both the ICC and the LC have the same powers as vested in the civil court under the Code of Civil Procedure 1908. So they can summon, they can enforce attendance, they can require discovery and production of documents. So their powers are quite good. Now, what is a complaint mechanism? Now, before going into the actual complaint mechanism, let me tell you, there is also something called as conciliation. This basically, simply put, it's like an out-of-court settlement. So before initiating an action, the woman can try to settle it just between the parties rather than going through the entire process. So this is an informal method. Monetary settlement cannot be made on the basis of conciliation. So you cannot ask a compensation that is, money. You can't through conciliation. Another important thing is that once the settlement is arrived, the IC has to still record this and provide copies to the aggrieved movement as well as to the respondent. And the second most important thing is that you cannot then proceed with inquiry against under the POSH Act. So conciliation, two important things: no monetary settlement, and you can't go to POSH once you have reconciled. Now, what does an aggrieved woman do when she has to file a complaint? 6 copies of the written complaint are required with supporting documents and witnesses who can speak in your favor. And this has to be within 3 months of the date of the incident. In case there were a series of incidents, it has to happen within 3 months of the last incident that occurred. Again, while some important points is there should be prompt reporting, and for any reason it could not have been done within 3 months, the ICC or the LC can extend the timeline, but they have to record the reason why it was done. And a very nice thing is that the law has provided for friends or relatives, co-workers, psychiatrists to file the complaint in case there's a physical incapacity, mental affected very badly, or death, then someone else can do it as well. So this is the timeline. I've just put it how they should be given, when they should be filed, when the copy, by when within 7 days the copy should be given to the respondent, the response back, then the conciliation or the inquiry, when the inquiry report has to happen, and finally the action. Again, a well-drafted complaint should be addressed to the ICC, please remember, and not to the employer or to the HR representative. That's very, very important. The complaint should be concise, exact details of the incident should be mentioned, circumstances before or after that occurred. Also, did the respondent, was he told to desist from doing these unwelcome acts? Was he given a warning, so to say? And as many documents as possible should be included. It can be emails, screenshots of WhatsApp, SMSs, call logs, repeated calls after work hours, photographs, recordings, all of it. And details of the respondent, like who is he, what is his, designation, whether he's senior, junior, colleague, all that should be mentioned. Also, it should be true, nothing false or incorrect, because then the inquiry will not go in the complainant's favor. And what is the relief that is sought from the employer? You want that person to be removed from office, you want a monetary compensation, you want a written apology, you want counseling for that patient, a person, all that. Now, so this is how the inquiry report happens, from the documentary evidences to the list, to the dates when what happened, to the copy of the complaint and the response. Then finally, the recommendation along with the verdict and the recommendation. So let's look at what are the punishments and the compensation. They are very simple. The first thing, and probably one that would bother one a lot, is the deduction of salary. This is basically what is used to pay the compensation. Then, of course, there are other things like community service, counseling, termination. That's also quite important, because if this complaint with this kind of a background, future employment becomes difficult. Withholding of pay rise or increments, withholding promotion, reprimanding or censure, or a written apology or a warning. So these are the recommendations against the guilty. Now, when the compliance by the employer is not there, to constitute the IC, there will be a penalty of 50,000 should this be brought to the notice of the authorities. Also, repetition of the same offense can cause, revocation of the license itself. And another important thing about all offenses under POSH Act is that they are non-cognizable. Now, next is few of the other laws that pertain to workplace sexual harassment. This is the industry employment. So this is one that wherein there are standing orders and sexual harassment is not limited only to women. So that's an important thing. This is applicable to across genders. And then you have the IPC. In that you have many sections. So I will not be covering all of them because each one of them will take a long time. And the last and important thing is also the Companies Act. Basically, the Companies Act says that you have to have the ICC under the POSH Act. Here, under this act, the fines are much higher, and some of them extend up to 5 to 25 lakhs as well. So again, this becomes important because if whenever POSH is not complied with in the company. This is an interesting tool, online platform that is set up by the Ministry of Women and Child Development called as the She Box. You can be used by both government and private sector employees, and all complaints will be sent to the government by the government to the employer. And the progress of the investigation will monitored by the ministry itself. So that way, in case there is no ICC or you want to complain against the employer, this is again a good platform. Now, from the time POSH came in 2013 to now, you can see that the numbers are only getting higher. That means they're getting reported higher or being occurrence itself is higher. It's tough to tell. Like I said, women are getting more and more into professional workspaces. So obviously the harassment is only going to increase. You will see, not surprisingly, a dip in COVID-19, wherein everybody is working from home. So sexual harassment at workplace didn't really occur. Now I'm going to come to the last segment of my talk, where I'm going to speak about some 5 important judgments, which tells us on how the interpretation also becomes very important of these laws and rules. Now, there was one complaint at the Calcutta High Court where an employee of an educational institute filed a sexual harassment against another employee of the same gender. So whether same-sex harassment is maintainable under POSH Act? Well, if you see, this was a very nice statement that the judge gave. He said, although it might seem a bit odd at first blush that people of the same gender complain of sexual harassment against each other, it is not improbable, particularly in the context of the dynamic mode which the Indian society is adopting currently, even debating the issue as to whether same gender marriages may be legalized. So it upheld it and said that same gender harassment is maintainable under the POSH Act. So this is one of the interesting things that was fought in the High Court of Calcutta. Next was the definition of workplace in the digital work world. Here again, an employee of a bank approached the High Court of Judicature for Rajasthan, requesting the court to quash the report of disciplinary authority of the bank. So some of these banks have their own disciplinary authority, maybe under POSH, but not the ICC. So basically what has happened here was the petitioner accused of sexual harassment by an employee of the same bank, but who worked in a different state. The second thing was harassment happened beyond work hours. So these were the 2 main things that was contended here. So what the judge here said was that it should be treated completely as one workplace on a digital platform, because you see now all the banks are on the World Wide Web and they're all connected when we can bank at any point of time. So they said that no, that just because it's in another branch, you can't say that it's not applicable, because he very clearly said that sexual harassment should occur only at workplace, and this was not at workplace. And it was after work hours. And the second thing that the judge says that if messages are sent after working hours, it would still cause harassment and prima facie would come within the meaning of misconduct under the regulations of 1976. So again, this thing was court squashed the petitioner. Like I said before, an ICC constitution is very, very important, and there are set guidelines. We discussed about that. So in this particular case, a student filed a complaint of sexual harassment with the ICC, but she was not very happy with the constitution of how the ICC was made, and she complained. You filed a writ petition against the institute at the High Court of Bombay at Goa. So here the court passed the judgment in favor of the petition and said that they agreed that the constitution of ICC was not in accordance with the Regulation 4. So again, a new ICC had to be set in, and she was heard for the harassment that she had in her college. Is the sole testimony of the victim of the sexual abuse sufficient? So this was, I think, a paramedic course. The guest instructor had come, and on the way back while traveling, after some sort of exercise, he harassed one of the trainees in the cabin of a truck, and he molested and sexually harassed her. So though the ICC found him guilty, he appealed, saying that this case, when it came to High Court of Uttarakhand, he said that it is not appropriate from the inquiry committee to rely solely on the testimony of the complaint to take action. But the court said no, the sole testimony of the victim is sufficient in a departmental inquiry, since the standard of proof used is preponderance of probabilities. So a disciplinary proceeding is not a criminal trial. So you can consider the sole testimony of the victim. So this is the last thing, an interesting thing. An employer filed a sexual harassment complaint against a co-worker. The IC conducts the inquiry and concludes that the complaint and the respondent were in a consensual relationship. They rejected the complaint and made observation that the two parties' behavior was unbecoming for their roles and recommended to the competent authority to take appropriate action against them. So they filed a writ petition, and very clearly the court said that moral policing is not the job of the management or the ICC. Any consensual relationship amongst adults should not be the concern of the ICC, and they should rule only as far as the disciplinary or the sexual harassment conduct goes. So here again, they lost the case. So let's do a quick recap. It'll be nice if y'all can answer, if all of y'all. It'll just be a recap of what we've just gone through now. It's not tough. So can I request y'all just quick answers?
Sure, ma'am.
Yes, ma'am.
Yeah.
Yes.
So
All of us are around, yeah.
yes, can both men and women be victims of workplace sexual harassment?
No.
They can be,
Victim.
Yes.
Yes.
yeah, they can be
Yes.
victims, but not under POSH
Posh is only for
for women.
Yeah.
women, yeah.
They
Can
can,
verbal contact amount to sexual harassment?
Yes.
Yes.
Yes, absolutely. Is the employer responsible if an employee is sexually harassed at a company-sponsored event, our banquets, for whatever you, so many events that we have, whether it is during work hours or outside of work hours, would they still?
Yes.
Absolutely. Any company-sponsored outside work hours will come under the scope of POSH. When is an establishment required to constitute an IC?
More than 10.
More
Absolutely.
than 10.
Is an IC required to be constituted at every branch or office?
Yes.
Not needed.
Not necessary.
Yes, it is.
Yes, it is. It
Yes,
is.
every branch, every office, and the number has to be 10. So more than 10, any branch or office would normally have. So they have to. Can the complaint be
But
filed
then I'll
with?
just interrupt here.
Yes.
Even if there are many more branches of that particular branch, even if the incidence occurs at one place, even other places considered.
If it is less than 10, sir. Otherwise, if it is more than 10 employees, they have to have their own ICC.
Okay.
Can the complaint be filed with and inquired by the HR manager of the company?
Yes.
Complaint can be filed by, but inquiry cannot be the part of it.
Nothing.
Okay.
The complaint has to be addressed to the ICC. You
So
cannot.
filing cannot be done by HR.
No. So apparently, some cases have gone to HR and they've been squashed. It has to go to ICC because the HR manager cannot be fair, because the other person may also be, there might be some amount of bias. So HR manager of the company cannot be the person who will accept a complaint or file a complaint. Both. It has to be only ICC. Is there a time limit for filing a complaint?
Actually 3 months, but after that it can be
Yes.
extended.
Can be.
Oh,
Can a complaint of sexual harassment be conciliated, mediated?
Yes.
yes, it can be.
Yeah, only thing is you don't cannot expect any monetary compensation. Yes, so that's my last slide. Thank you very much for the opportunity. I hope I was able to do justice.
Thank you so much, ma'am. The talk was very informative. And the last part of it, question answer, was actually good to know the practical tips and one-liner thing, which probably we would have missed otherwise. So let's hear the comments from our panelists before we go on to the questions from us. So over to you, Marathe sir, for your comments first.
I think it was wonderful talk given by Dr. Chaitra. It was perfect in all aspects. I think every point of sexual harassment was covered by her. And definitely it's related even to medical profession like clinics, hospitals, conferences, banquet, she has said. A few important things like incorrect complaint against anyone by the lady. That is the thing. Can you elaborate a little bit upon this point?
So, if any incorrect complaint is given, then there will be some sort of disciplinary action against it. What other thing will be based on, frivolous complaints? They actually call it as frivolous complaints. You do it to seek revenge, those sort of things. So, those are again investigated. It's not that they won't be checked, but if it is done, the false or malicious complaints, in that if the allegation is false or malicious, then the reprimanding will be done to the person who has made the complaint. Adequate proof will be not available in those cases, and they should give a letter of apology. Same sort of disciplinary action can be taken against the person.
One
Frivolous
more
complaint.
thing.
Yes.
I think it is said that whenever there is the this particular law
Mhm. So,
to give the proof,
you're
but
not
it is up to
audible.
that person, up to that gent, that male.
Marathe sir, can you please repeat the question? Your voice was not clear in between. Can you please repeat it?
Yeah. Am I audible now?
Yes, sir, you are.
Suppose there is a complaint by a against the man. What I understood in the past, I may be wrong, that it is up to the man to prove that he is not guilty, rather than lady proving that she was harassed.
The onus of burden of proof is on
Yeah.
the complainant or on the
respondent.
respondent.
No, it's primarily on the complainant.
But
She has to
should be.
have all the
That should be.
evidence. She has to provide the evidence. Obviously, some sort of when the inquiry happens, you will be able to respond to all those complaints, but to prove it lies with the woman. And even if there is no evidence like a screenshot or anything, just her complaint that my modesty was outraged is enough. Because you
that's what I'm
cannot,
saying. Yeah.
you cannot have proof for that. It's a feeling.
Exactly.
You can't
Exactly.
say, I went for counseling. This is proof that it affected me mentally and emotionally.
And every time witness may not be available. So
Exactly.
that is the problem in such cases.
Because the first thing a male would do is deny.
Yeah.
So you can't be the
One
and another
important thing.
Yeah, another important thing is in the complaint, when the thing is giving any precedence. Suppose that person has been a repeat offender. So even if there is no proof for this particular incident, the previous incidents will also add, because the ICC will have a record.
Suppose you have the institute where more than 10 people are working, and still that ICC is not formed, and then the complaint comes. What happens to that particular institute where ICC is not formed? Now
So
the complainant is from the same institute, and the same that a person troubling the lady is also from the same institute. Now the punishment will be there to that person who has done the harassment. The same way, what happens to the institute,
It's
which
there's
has
a
not formed that ICC?
fine of 50,000.
Okay.
If she has no ICC in the institute, she will go to the district level IC or
Hmm.
the she box. After that, the authorities will then take action against the institute for not having done it. If they do it under the Companies Act, the fine is even more. And even after the first warning, if you don't, there is also, it's punishable with imprisonment for a term extending up to 3 years and a larger fine. So this is very important. That comes under the Companies Act, which is more strict than the POSH.
What if
One,
the ICC is formed after they receive a complaint?
Then it's okay, sir.
Okay.
If after the complaint also they don't do it, then the compensation is it's very, very high, the fine. In fact, I think there is one case in which the court has directed the hospital to pay almost, I don't know, 2.5 million. This is some very, very high because there was some failure to constitute the IC and she could not get, the required support. There's a very large amount that was asked to be paid.
now, in case of rape and other sexual harassment cases, the role of the medical practitioner is very important.
Hmm.
Now, in this case, it may not be directly related to physical examination by the medical practitioner.
Hmm.
What is the role of medical practitioner in this case?
It don't depends on the extent of the sexual harassment, sir. In case there are two ways to look at it. One medical practitioner was probably required to counsel, to take care of the mental health of the person. The second would be if there are any physical, insults, treatment is required.
And
In
in
that
this case, it
supportive
will
role,
be a criminal case. And in this situation, it will be a criminal case.
criminal
It has to
case.
be reported to the police, and the police has its own rules and regulations to handle such cases.
And we'll be giving very important evidence. So all that will need to be taken into consideration.
Like in case of rape, suppose the patient goes to the medical practitioner, he or she has to inform the police. Like such and such sexual abuse case has come to his place or her place. So this is regarding rape cases or sexual harassment cases. Now, in this case, the patient may not go to medical practitioner for each and every incidence.
Mhm.
But direct sexual harassment or rape type of cases, they are going to medical practitioners and they have to report that to the
Yes.
police.
Yes.
That is one thing what I
No.
feel.
Yeah, but actually, even with these harassments, what happens when patients come to you? And we are actually duty bound, legally bound to inform our local police station. I have had patients who have told me that please don't. If you report it and they come to inquire from my partner, things are going to get violent and worse for me. So, at that point of time, because I've had a patient who was physically and sexually abused. She came for treatment because she had lit tear. And when I told her we have to compulsorily inform the cops, she said no. So then, as per law, you have to inform. But
Yeah,
as
that's
per patient's confidentiality, you're in a mess because patient says, I'm coming to you in confidence. You're breaking my, confidentiality, my whatever, my personal equation that I have with you. And if my partner gets to know I've complained, or forget it, if I've even come for treatment here, he's only going to hit me more or
But that
I
abuse.
is
think these are the controversial rules and regulations.
Yes, exactly.
But the first thing is you must inform. That's what the police says. The law says. Otherwise, the medical practitioner is in trouble.
Law
Not
says that,
informing,
sir.
I have seen doctors, they have gone behind the jail,
Yes.
behind the bars rather.
but that is for domestic violence, or ma'am, was that a workplace incident?
This was a domestic harassment, both emotional, mental, physical.
That cases I think come quite often, I think.
No, but Dipanshu, what do you do there? You have this fear that you go to the cops and tell, and they will go and catch him or give him a warning, and for the next day he could,
The incidents will come.
yeah.
So, sir, and also the consultant can tell, no, this is an alleged, no. How do you know how exactly this happened? So, if the patient is not wanting it to be a police case, etc. So you are in a dilemma, moral dilemma, how to do. And how does it come to you? You can say that I did not know the mechanism of injury. I just treated the injury.
Actually,
Like,
there are two extremes, no, Kaushik. I remember from our internship time when we were posted in the burns ward. Initially, when the women come, they used to all tell that hot water spilt on me. I was doing this by mistake. The minute they realize that they are not going to survive, that is when they used to come out with the truth. Say, my husband did this, my boyfriend did this, my owner did this. So things are very volatile, you know. So sometimes they come with the truth, or they come with an allegation, or sometimes they come with the truth. So how do you know? I that's why that word alleged is so very important whenever we write our NLCs.
Uh, I think Kaushik, there were cases. Most of the times, clinician feels when the parents and patients they tell that this was not sexually abused case. But then afterwards, once you have treated and you not reported to the police, afterwards, when if all investigations are done, or in future, suppose that case is directly related to sexual harassment case, then Kaushik, then the doctor is in trouble. Mathur
I
sir.
think, Madhu sir.
I didn't get it. What exactly you want to know, sir? Please repeat the question.
You want it from me?
Yeah,
Oh,
yeah,
sir,
sir. Yeah, what's the question?
No, it was not question. It was a
no, sir,
comment.
we just wanted your comments. Like Dr. Marathe sir commented on ma'am's presentation. So we just wanted your comment
Okay,
overall about the
Yeah.
session and
Yeah.
about the topic, sir.
The least I can say is Dr. Chaitra, she presented a wonderful exposition about this topic. And sexual harassment is clearly highlighted that it need not be just physical. Like the definition of health, it can be physical, mental, social, and spiritual too. Like in all the four aspects, if there is a harassment, and this harassment can be at the workplace, at the domestic level, at the domestic level. But what is important is any institution or any office with more than 10 employees should have an ICC. And the role of this ICC, a woman can certainly complain. It's just the woman or even a man, can he complain about his wife of a domestic harassment? Chaitra, would you like to clarify this?
Sir, come again,
There
sir.
is an ICC. If there is an ICC, if you want to be a gender neutral person, ex-wife is harassing ex and ex is not happy, can ex complain to the ICC of that particular institute?
Yes, as long as there's at least one woman involved.
Yeah.
One
So
woman should be.
basically what is happening is just predominantly a female this thing, but it can be a gender neutral issue.
Yes.
But what is important for us to know is that there has to be an ICC, and there are specific penalties imposed if an ICC is not constituted. And
Absolutely.
ICC has its own role. ICC in heinous cases has to mandatorily report to the concerned authorities. ICC at best can just convince that particular victim to permit the ICC to complain. Am I wrong? If like you just gave an instance that the person doesn't want the ICC to complain, to take up the issue with the police, but it is a heinous crime. Can the ICC convince the patient and person and try to report it, or they are duty bound to protect her privacy?
That will come under IPC, sir, then.
IPC. Yeah, so that's what I get out of it. If there is an IPC complaint, it should be reported to the concerned authorities. And yeah.
So, thank you so much, Mathur sir. Ma'am, I wanted to ask one question that are there any reported incidents where the men were harassed at the workplace and they have complained and then any legal action was taken against the woman boss or employee or whatever?
Not under POSH.
No, not under POSH, in general. POSH is purely for women.
General, yes. In general, there are quite a few, but I didn't go into it because we were basically looking at women centric talk. There are.
POSH is basically female centric.
Yeah, female centric. Dr. Riddhi, you have any question?
No, ma'am. We had a
Sir.
very enlightening talk by Dr. Chaitra.
Yeah.
concise
I had
and
a
to the
question, like if somebody is examining a female patient, even in ophthalmology, like in retina, you might have to, the patient might have to lay down and you are examining with indirect, etc. So can an ophthalmologist be implicated and how can the ophthalmologist save him?
By having female staff in the room, probably.
In
And
your individual clinic, luckily there is no direct ophthalmoscopy these days.
No, even you are doing the routine retinoscopy or vision checkup or putting glasses in the trial frame, and if by chance there is a touch, these cases have happened.
No,
There
we've
were
had
complaints.
patients.
Yeah.
We've had patients who objected to the light being switched off, who objected to the chair being reclined. So they're serious concerns. So especially new patients who don't understand that, this is part of a retinal examination. She had given a written complaint. I was uncomfortable. I was in a dark room and the chair was reclined and the doctor was standing very close to my face. Because, I mean, especially because it's a male, it's a very understandably uncomfortable situation. So either you explain to the patient, and if it is a girl, young woman, whatever, have another female, would be your fellow, your PG, your, assistant, someone. Or don't switch off the light, or, it is uncomfortable. I mean, if you
Better
put
to inform the patient and then do it. Like even suppose if you're alone, you just inform the patient that I have to switch off the light. I have to do this indirect ophthalmoscopy, for example. Like I have to do it. And then it's better to tell the patient and try to do the test.
And sir, what is the status of like camera, having a CCTV, etc. in your examination room? Like, is it allowed,
I
not
think it is good to have a CCTV in your consultation, in your reception. Apart from gynecological examinations and physical examination by routine physician, even in ophthalmic clinics, definitely CCTV can be accessible and it can save you. That is number one. But in case of gynecology, still the consultant is communicating to the patient that CCTV can be operable. But when exact examination is done, CCTV has not to be operable at that particular thing. But one important thing, what we have discussed just now, that lady attendant or lady companion can be there along with the patient, maybe patient's relatives, or what she said, that someone from your clinic. That's very important thing because that becomes the proof that someone else was present in your room. Some lady was present, and in her presence, you have examined the patient. That's very
Patient
important.
defender would be ideal, actually.
Yeah. And in case of ophthalmology, even Mathur sir will agree, Dr. Chaitra will agree that CCTV access definitely will be helpful.
Yes, in ophthalmology clinics, yes, if you have
Yes.
an access to that, that acts as a good proof.
have any of you all had any incidents at your centers or anything?
Not yet, ma'am.
Not yet. That's good. No, because we've had it. We've had quite a few, and they're rather unpleasant. And unfortunately, they're all. One of them was even concerning a senior, ophthalmologist. So, what goes on? Why it goes on? The regret after that, maybe very. Not we don't perceive that, we don't understand it, but it is there. Like the Nair incident, if you see, it's by a doctor. So it's not like our profession prevents anyone from being, like any other male who's the perpetuator. So you can't tell it. We've had incidents. I mean, we're a large organization.
I haven't had, but Dr. A. Deshpande always speaks in his talks about that lady complaining at the time of ophthalmic examination and gone into court. Other incidents what I've heard at the time of banquet. Few females they have complained misbehavior by companion doctors, judge doctors. I
Yes.
think banquet are very problematic things nowadays. We should be
Right.
careful. Even this has happened with the people, those who are presenting at the time of banquet. And few of the doctors, they were in trouble.
Chaitra, I have a question for you. Like,
Yes.
since, like, specifically myself, I'm being in ophthalmology administration at the national level. What are the precautions that we need to take since we have discussed conferences also? Is it mandatory that we have not been doing till now, but is it good that we form an ICC for every conference that we organize?
Not really, sir, because those are not organizations. They are meetings. They are short-term meetings. You don't need to. But if you have a redressal at the apex, you have several committees, you should have this. I think, it will be very forward thinking to have a committee wherein most of your members are now women. Most of your members are women. And since conferences and banquets are extensions of workplaces or an organization, and like Sir mentioned, crazy things have happened. So, I mean, I don't know whether Riddhi and Aarti have seen this, but I have. I mean, I've been subjected to ridiculous behavior after a couple of rounds of drinks in the meetings. So people lose their inhibition, so they tend to cross the line. So if there is a way where they can be issued a notice saying that, this behavior is not acceptable, it will be nice, sir, because more and more women are joining our field.
What I
So
was thinking is, like, since we already have a women redressal subcommittee, presidential committee, we can increase the powers of that committee on similar these things, and we just elaborate their role, and then we include this ICC activities also under that panel. So in case, God forbid, something happens in the future, like we have some mechanism to fall back to. I think I shall definitely suggest this to the incoming president. At least we have a committee for this purpose, or at least incorporate these provisions in the women redressal committee that we already have with the IOS.
Sir, it will be good to make people aware that there is some option like this, because at times what happens is you just get harassed or something like that, and then you're like, this conference is getting over or this event is getting over, and then you don't talk about it. So this has happened even with me, but it was outside India, and it was by an Indian actually in Greece. So it's
Actually,
like,
we
yeah,
perfectly
so it's like
understandable. Like,
you really can't go anywhere, and where will
Right.
you go in the foreign
Right.
land? So
Right.
nothing came after that like that.
So,
So
like, if in such a situation, one technicality would be like the incident has happened in a foreign land. At least if we have an AIOS committee for that, probably if we have some avenue to take up the issue, that should be in the right line, probably. Because, like, if such a situation occurs, like our Indian criminal system or the police would not be inclined to take it up, only because the incidents has happened outside the jurisdiction. In such situations, why not the professional committee? If we have one, I am giving a serious thought. I will certainly suggest to the president next year, like when we are forming the committee, this should be taken into account.
One
just
of
a
the things
warning,
which is sorry.
just a warning also
Hmm.
might be like a
Yes.
thing which people will
Yes.
keep in mind. Maybe like the males will also keep in mind, and females will also be aware that there's something like this. Over to you, Marathe sir.
No, one of the things what I've heard, and it has been planned successfully in few of the conferences, number of pegs in that particular conference, alcohol restriction, like giving coupons to those who want to drink, restriction on that. That definitely helps. So, to some
We
extent,
are digressing.
no, this is being applied at few conferences.
So to be honest, like especially in our ophthalmology get-togethers and our ophthalmology conferences, I think the incidence is quite negligible compared to the other specialities. I think we
Maybe
all
because
know
we have a lot
about.
of women
Yeah, there's
in
no
the
need to,
field of
like, all of
ophthalmology.
us, we need to ration ourselves, and we need to, especially the very information that if the IOS members are knowing that this sort of a committee exists, probably that will act as a big hindrance and big restriction on their thought process for sure. I think. I personally, I am not inclined to believe in rationing, sir. Like, you need to control yourself. How
I don't
much?
drink, so I'm in demand of those
Yeah.
classes.
Like I have been, I do drink. I accept from 1978, so I'm probably one of the senior most. But even to this date, I restrict myself to one.
Yeah.
So that's a different thing. We are
But that is not the
Yeah,
justification.
but it's just for company, but for socializing and this thing,
No,
like
but I think no, Dr.
okay,
Mathur sir, it has definitely helped. If there is no availability and if there
presence
is
of
restriction, the
committee,
chances go down.
just the information that this sort of a committee exists will be enough to just send out the word that these kind of things are not taken lightly.
Like we have food committee, like we have lost and found committee. So similarly, we can have something important.
No,
Dipanshu,
no,
you
no.
raised your
Aarti,
hand, Dipanshu.
no,
Go on.
Aarti, it's not that. I am saying it should be on a permanent presidential committee level.
Yes.
Like, every conference, if we form an ICC, for example, that will give a bad reputation to the organization AIOS, basically. I'm very honest about it. Like if I am organizing a conference, I'm constituting an ICC, that doesn't speak well. But if I have a permanent committee of AIOS, a presidential committee handling these things, that should be enough.
I have a doubt, ma'am, as ma'am mentioned that every hospital or institute should have a committee. So, like, will it be fruitful from the AIOS or AIOS medical legal team that if we roll out a small survey to assess, like, what is the
Whether they
status
have a
at each
committee
institute,
and
whether there has
yes.
been an incidence, whether there has been whether there is a committee available or not, and the previous incidences, if they have to be reported, probably an anonymous survey, but just the name of the place and institute without the name, if that can.
Dipanshu, we can do that, like the way we
Yeah,
did for
YOSI
indemnity
can do it.
insurance.
Yeah,
Yeah.
YOSI can do it. You can send a mail or you can send a information to all the institutes and all the AIOS members, wherever they are working, whether there is an ICC. It will be interesting to know how many institutes they really have an ICC. And as Chaitra said, like every department, if there are 10 or more in a particular department, every department should have an ICC. Do they really have it, or do they have it only at the institution level?
I think
That-
at
that's an
institution
interesting
level, it's enough, sir.
That's
Not
enough.
within
Yeah,
the
not the
same
department.
institute, you don't need for different departments. Like we have an ICC wherein one of our senior consultant is the chairperson, and we have an external person who's from an NGO. She does a lot of work with slum women. So we have an ICC, but the point is, along with this survey, you should also give recommendations. If
Yeah.
see, we are not going to gain anything by knowing which hospital has and who doesn't. But if you don't have, this is mandatory as per the law, is what we have to tell. And in brief, like, how we just spoke in the talk, what are the main things that's required? I think that way you should also spread awareness as we're collecting the information.
I think the mail should go from
Take up
AIOS
this
about the
initiative.
recommendations rather than
They
survey.
can
Survey
take
can
up
be
this
done.
initiative. They can take
So
the
once
help
we
of
have the
Chaitra.
results, maybe we can publish that along with the recommendations, probably something like that.
Publish the status and then publish the recommendations.
Recommendations
Yes.
along with that.
How to go
I think
about
it's
it.
also a requirement by NABH, if I'm not sure. I
Yes,
think
yes.
it's also mandated. So
Maybe
most
we can
of us will have it.
But still, I feel, ma'am, a lot of people, a lot of institutes might not have it. Actually, probably some medical colleges or
Will they
Actually,
admit
it is
that
a
they don't
process
have
of
it, Dipanshu?
NABH also. Like I think even the small hospital, like for example, where I work, like it's an NABH requirement. You have to show it, you have to document an ICC. Every eye center. Every eye center that is NABH recognized has to have an ICC.
And another thing is, after the RG car incident, it's become now even more aware. Everybody knows that, they'll be in trouble if they don't have it. A lot of awareness came. That's how this whole Nair thing also got, taken up so immediately. And the doctor was asked to leave the center.
So, does anybody have any question or any comment? Because we have almost reached our time. It's 10 o'clock already. So, I would like to thank you, Dr. Chaitra ma'am, for taking up this topic, and you've covered it really well. We are thankful to Dr. Manoj Mathur sir and Dr. Prakash Marathe sir for their active guidance always in our series. Unfortunately, Dr. Deshpande sir was not able to join us, but hopefully we will have some other topic related to this and we will hear his points as well. Thank you so much, Dr. Riddhi, for moderating this session along with me. And at the back end, I would like to thank Dr. Dipanshu and Dr. Kaushik to take care of so many other technical things. Last but not the least, I would like to thank Manjula and her team for the technical support. So we will see you soon for our next session. Thank you, everyone.
Thank
Good
you, ma'am.
night.
Thank you. Good day.
It was a very interesting
Thanks
talk.
to all
I
the
mean,
delegates, those who have joined.
Thank you. Thank you.
Thank you. Good night.
Thank you. Good night. Bye bye.